Hello friends, welcome to my YouTube channel, Attorney Immigration Lawyer. Today's episode, we're going to talk about the removal or the discontinuance of I-944 Declaration of Self-Sufficiency. Before we start, I want to introduce myself. My name is Attorney Elaine Antonio Bordeaux. I'm a U.S. immigration lawyer. Been practicing immigration law for 13 years. And if you want to know more about me, please visit my website, www.eboardlaw.com. Okay, so there's a lot of changes that happened during President Trump's time. And now with the Biden administration, as expected, there's a lot of changes. There's a lot of undoing that happened and will continue to happen. And one of these is the I-944 Declaration of Self-Sufficiency. This form was put in place during the Trump administration time. Ito po yung form kung saan kailangang i-declare ng magpa-file ng extension of stay or adjustment of status, yung kanilang assets, liabilities, yung kanilang credit report, kung nag-i-English, kung ang kanilang proficiency sa English language. There's a lot of litigations that happened in between, and finally, on March, beginning March 9, 2021, this was announced by the Department of Homeland Security. Applicants should not file Form I-944, Declaration of Self-Sufficiency, or any evidence or documentation required on that form with their Form I-485. The Form I-944 has been discontinued effective March 9, 2021. Okay, so hindi na po natin kailangang mag-file ng I-944 para po sa adjustment of status ayon po dito sa announcement ng USCIS. USCIS immediately stopped applying the public charge final rule to all pending applications and petitions that would have been subject to the rule. USCIS continues to apply the public charge inadmissibility statute, including consideration of the statutory minimum factors in the totality of the circumstances in accordance with the 1999 interim field guidance that was in place before the public charge final rule was implemented. Ang sabi po dito, itong form na ito, itong I-944 at itong public charge rule effective February 24, hindi na po ito ina-apply ngayon. Pero it doesn't mean na wala na pong factors na kinukonsider. Meron pa po. Ito yung dating rule, yung public charge inadmissibility statute. USCIS will continue to apply that, including consideration of the statutory minimum factors in the totality of their circumstances. Nakasaad po yan sa 1999 interim field guidance. Okay? Pero para dun sa mga mag-file beginning March 9, ay hindi na po isasubmit ang I-944 at hindi na po nila ito kinukonsider sa adjustment cases. Okay, in addition, USCIS will no longer apply the separate but related public benefits condition to applications or petitions for extension of non-immigrant stay and change of non-immigrant status. So yung public benefits condition na which was also put in place during President Trump's time ay hindi na rin po i-apply sa mga magpa-file ng extension of non-immigrant stay, yung po mga extension ng tourist visa, especially yung mga na-stuck dito sa at hindi nakabalik sa Philippines, and change of non-immigrant status. So yung from one non-immigrant to another, ay hindi na rin po magiging subject sa public benefits condition. Okay. On or after March 9, 2021, applicants and petitioners should not provide information required solely by the public charge final rule. That means that the applicants for adjustment of status should not provide the Form I-944 Declaration of Self-Sufficiency or any evidence or documentation required in that form. Okay. Applicants and petitioners for extension of non-immigrant stay and change of non-immigrant status should not provide information related to the receipt of public benefits on Form I-129. They also changed kasi yung Form I-129, if you remember, at meron dun mga katanungan tungkol sa pagtanggap ng public benefits. So ang sabi po dito sa announcement ay ang applicants and petitioners for extension of non-immigrant stay and change of non-immigrant status should not provide information related to the receipt of public benefits. So hindi nyo na kailangan sagutin yung mga tanong na yun. Paano naman if you already provided this form? Okay, if an applicant or petitioner has already provided such information and USCIS adjudicates the application or petition on or after March 9, 2021, USCIS will not consider any information that relates solely to the public charge final rule. So kung na-submit nyo na at na-file nyo na itong I-944 before March 9, 2021, at pending pa siya, USCIS will not consider any information relating to that. Okay. If you receive a request for evidence, ito naman yung para dun sa mga nakatanggap ng RFE or notice of intent to deny, requesting information that is solely required by the public charge final rule, including but not limited to Form I-944, and your response is due on or after March 9, 2021, you need not provide that information solely required by the public charge final rule. So pag nakatanggap ka ng RFE at ang response due date mo is on or after March 9, 2021, hindi nyo na po kailangan mag-provide ng information solely required by the public charge final rule. Okay? You do, however, need to respond to the aspects of the RFE or NOID that otherwise pertain to the eligibility for immigration benefits. So kung ang RFE nyo ay may iba pang issues other than itong public charge rule, ay kailangan nyo pa rin sagutin yon. Okay, so don't miss that. If USCIS requires additional information or evidence to make a public charge inadmissibility determination under the statute and consistent with the 1999 interim field guidance, it will issue a subsequent RFE or NOID. Okay, so as I said, hindi naman po absolutely wala na pong public charge inadmissibility determination. Mayroon pa rin po. But in that event, USCIS will issue an RFE or NOID consistent with that statute and with the interim field guidance. Okay, in other words, kung ang tanong ay tungkol sa public charge final rule ni President Trump, ay hindi na po kailangan sagutin at hindi na po nila kinoconsider beginning March 9. Pero kung tungkol sa ibang information about the immigration benefit that you're seeking for or you're applying for, you still have to respond. All right? So yan po ang ating explanation, ang update about I-944, Declaration of Self-Sufficiency. Marami pong nagtatanong at nalilito. So yan po ang sagot natin. As of March 9, hindi na kailangan mag-file ng I-944. And depende po kung nakatanggap ng RFE ay depende po sa issue dun sa RFE. Kung tungkol sa public charge final rule ay hindi na po nyo kailangan mag-provide ng information. Tungkol sa public benefits ay hindi na rin po. Pero kung may iba pang issue or katanungan or evidence na nire-require ng immigration, you still have to respond to your RFE or notice of intent to deny. Okay, so I hope po ay maliwanag ang ating explanation. If you like this video, please like and subscribe and please share this to your friends para po makatulong tayo. This is Attorney Elaine Antonio Bordo. Thank you po. Till next time.